Ladies and gentlemen, if I can have your attention, good morning. It's a bright, sunny morning in Athens, and we're very happy to welcome you. I would like to welcome you on behalf of the Athens Public International Law Center, which is co-hosting today's conference with Professor Merkouris from the University of Groningen, of course, and the Faculty of Law, in the context of a very ambitious project, which I think is reaching its end, if that can happen with interpretation under international law, but who knows. And we're very happy to have you with us, all the colleagues who've come from the University of Groningen with Panos. The younger colleagues, I've seen some of them this summer and recently. Professors, friends from Groningen, but also from other parts of Europe. And we also have the honor to have with us, following today's conference, two colleagues from the Diplomatic Academy of South Korea. Welcome, sirs, welcome to you. Some of us have been following this project, working on aspects of it through the years. Andreas is nodding. In other contexts within the International Law Association, but on different aspects. And so we've followed what Panos has been doing from the beginning, or trying to follow. He knows that I don't always understand what he says and what he means, but I think that's what interpretation is here for. So closing this conference, there will be, again, I guess, an overarching discussion on many issues today, both today and tomorrow. And from what I understand, the project is so ambitious that there will also be a discussion on some guidelines on interpretation. Hopefully, some institutions might want to follow those guidelines, but let's see the context first. I just wanted to really welcome all my colleagues from everywhere. I'm very happy to see you all. Of course, my Greek colleagues as well, but I'm mostly happy to see the people who have come from other parts of the world. Thank you very much for being with us. We want you to be part of the Athens Public International Law Center. Most of our former students are, by the way. And so welcome, and I look forward to an interesting discussion on methods of interpretation of customary international law. I'll make one remark coming from the other hemisphere. A few days ago, I followed a discussion on whether some rules pertaining to deep seabed mining and the area on exploration and exploitation might have the status of customary international law. I was quite surprised, I have to say. But coming here, I thought I'd sort of throw that in as well, because deep sea bed mining, customary international law, maybe we need to see a few things. So thank you very much, Panos, for deciding to hold this conference here with us today, and I give you the floor immediately. Welcome, everyone.
So thank you, Professor Pazarzis. I presume that mention about deep sea bed mining and customary international law is your suggestion that maybe you want to present about that? By all means. No good deed goes unpunished. As Professor Pazarzis already said, let me also express my gratitude and my delight of having this final conference organized here together with Athens PIL and the National Kapodistria University of Athens. And of course, behind those names and those institutions, there are people. So Professor Pazarzis as the director of Athens PIL, among many other titles which should be printed out there somewhere. And also Professor Sicilianos, the Dean of the Faculty of Law, who unfortunately will not be able to join with us today because he was called by higher powers because there are some public hearings at the ICJ in The Hague. So we're going to be very, very critical of the ICJ because of that today. Of course, we'd also like to thank our phenomenal list, if I may say so, phenomenal list of speakers and chairs who devoted time to prepare their presentations and agreed to come here and discuss about issues of interpretation of customary international law. I won't name them each name by name. You have the booklets already, and everybody's gearing is more interested in hearing not an enumeration of names or me keep on speaking for a long time, but actually hearing what people have to say. A final thing, also because I'm contractually obligated, and I apologize for those of you who have followed previous conferences, but there's going to be a classical speech here that this conference is part of the TRICI-Law project, which we insist on calling TRICI, not TRICI, not anything else. It's TRICI, and the idea was that it is a tricky area of law. It was, I think, a couple of days spent trying to find an acronym that worked. And then I realized that everybody else, Hélène is laughing behind, who has a previous ERC starting grant, that anybody can choose whatever letter they want from wherever to make the acronym. So 2 days, well, not very well spent, but so be it. So the project is a 5-year project which is ending this month, funded by the European Research Council, and the idea was to examine the topic of interpretation of customary international law. This is our final event under the TRICI-Law project, but we do hope that we might have piqued the interest of people and generated a little bit of interest on this topic, so maybe there are others who want to pick up the mantle and continue discussing interpretation and why it can be useful and relevant in today's international scene. Thank you also to everybody who is attending here, either live or online. We have a lot of registrations online, so we hope that everything will go smoothly. And again, thank you all. Very much looking forward to this event. Thank you again to all the speakers, chairs, participants, and I think this is it on my part, and I think we can start the conference now. Thank you.
So good morning, everyone, dear colleagues, dear friends. First of all, I would like to say my pleasure to be here in Athens. It's always a pleasure to be in Athens, but I'm especially happy to attend this closing conference for this great program, International Customary Law, a tricky program, if I understood well. I belong to the club of people who have been fascinated all their life by international customary law. I did my PhD on the topic, and I remain fascinated by it. So I'm also very honored to be invited to chair this prestigious panel. From the middle, as I was trying to say, this panel is dedicated to the following topic: from identification to interpretation of custom, theory, limits, and interactions. It is true for the title of the conference as well as the title of the panel. Each term could give way to lengthy discussions when you speak about rules or methods or principles, about interpretation, about custom, about theory, about limits, about interactions. Panos sent us a very nice paper of 70 pages where he goes in depth in these issues, and also commentaries to the draft articles, although I have to confess I didn't have the time to read the commentary. So I'm delighted to chair this panel with 4 distinguished panelists. I will not spend a long time introducing them because, as Panos said previously, you have a very nice booklet providing the biographies. I'm delighted to welcome Dr. Maria Telalian, who will speak about the identification and interpretation of customary international law in the jurisprudence of the International Court of Justice. Before giving her the floor and then afterwards introducing the following panelists, I would like to recall the panelists that they are not expected to speak more than 15 and the maximum 17 minutes. And
it longer?
No. I'm a very tough timekeeper, and so try to stick to the time just for the sake of letting some time for the discussion. Yeah, no, but you know the difference between words and actions, so we will see. So the words are, please keep the time, and the actions will follow suit. So you have the floor.
Thank you, Madam Chair. And I understand the constraints of time, but in any case, I was prepared for 20 minutes intervention. Let me first of all most warmly thank the organizers of this event for inviting me, and also to congratulate Panos Merkouris for this very ambitious, as Mrs. Pazardi said earlier, project, the TRICI project. And let me now come to my presentation. Let me start by saying that we all know that the court is required to determine and interpret the rules of international law applicable to the dispute submitted to it in many diverse cases. And I would like to start by saying that Article 38 of the statute of the court lists international custom as evidence of a general practice accepted as law, as one of the primary sources of law, applicable, of course, before the court. Now, in the case of an unwritten text, which is, of course, customary international law, the court is confronted with the task to first identify the actual existence of this source of law and the scope of the norm that it includes. If there are, of course, other texts, for instance, written texts, treaties, codification works, or non-binding instruments, in particular the UN resolutions, then the court relies on these texts in order to examine whether there is a clear rule of customary international law, and in order also to understand its content. Now, as you know, I will now focus on how the ICJ, through its jurisprudence, and of course its judgments, advisory opinions, has engaged with customary international law, and whether the court has a consistent approach in dealing with this issue. Let me first make a few remarks before getting into the case law. First of all, the issue of customary law identification has been examined for a long time within the International Law Commission and also in the Sixth Committee in the past years. And allow me to say that work is still going on another unwritten primary source of international law, which is the general principles of international law. Now, a second remark is that the court is not simply limited in applying Article 38 of the statute, but as I said, when engaged of these texts, treaties, codification works, non-binding instruments, in particular UN resolutions, looks at these texts in order to determine, as I said earlier, whether a clear rule of customary international law exists and its content. And my third remark is that the approach of the court to the determination of what constitutes customary international law has evolved over the years as a result, of course, of the development of international law, the universalization of international law, and the process of codification and the progressive development of international law. Now, the changes in the court's approach to determine customary international law are well reflected in the judgment in the North Sea continental shelf of 1969. These cases, which eventually became one, in these cases, the court had to identify the principles of international law applicable to the delimitation of continental shelf in the North Sea. Now, we should focus on how the court moved away from its previous judgment in the right passage over the Indian territory of 1960, and highlighted for the first time, elaborated actually, the importance of the opinio juris in the process of the determination of such a rule. This is because in the previous case, in the right of passage over Indian territory, the court had placed great emphasis on the element of the repeated usages over a long period of time. So contrary to that, now the court focuses on the question of opinio juris as an element of, one of the elements actually, of custom. According to the court, for a customary international law rule to exist, two conditions must be fulfilled. Not only must the acts of state practice amount to a settled practice, but the states performing such acts must feel that they are conforming to what amounts to a legal obligation. As the court stressed, the need for such a belief, the existence of a subjective element, is implicit in the very notion of opinio juris sive necessitatis. The court made some further clarifications in that judgment that are worth mentioning. It stressed, for instance, the close relationship between state practice and opinio juris to the effect that the same act could be evidence of state practice and opinio juris. It also clarified that state practice can be also evidenced by the rules established in multilateral conventions, pointing out that very widespread and representative participation in such conventions might suffice in itself to generate a customary international law rule, provided that it included the participation of states whose interests are specially affected. Furthermore, the court in that case took a different approach from the one it took in the asylum case. In that case, the court equated the emergence of the custom with a tacit agreement. Now, in this case, the court drew a clear distinction between consent to be bound by a conventional rule and opinio juris, explaining that while a state may opt out from a treaty provision through reservations, it cannot do the same with respect to customary international law rules, which cannot be subject of any unilateral exclusion exercisable at the will of a state in its own favor. Let me now point out that the above two constituent elements for the identification of custom are also emphasized in the International Law Commission's draft conclusions on the identification of customary international law, and in particular in draft conclusion 3, paragraph 2, which emphatically mentions that state practice and opinio juris must be separately ascertained, something that is further explained, of course, in paragraph 8 of the LC draft commentary on Article 3. Now, let me now go to some other case law which indicates how the court deals with these two elements, state practice and opinio juris. Now, I also mentioned the right of passage case of 1960. And I said that the court had a different approach in the North Sea case than in this right of passage. Indeed, in that case, in the right of passage case over the Indian territory, the court held that Portugal was entitled to a general right of passage over Indian territory with regard to private persons, civil officials, and goods, and in this case, heavily relying on constant and uniform practice which of course existed during the British and post-British administration period. Now, it is obvious that the court in this case did not even bother to examine the element of opinio juris, either opinio juris of India or of Portugal. What appears to have influenced the above decision of the court was Indians' failure to object to Portugal's practice of passage, of course, over an extended period of time, although it could have reacted under international law. This assumption, however, should be dismissed today in view of the court's later statement in the North Sea case that acting or agreeing to act in a certain way does not of itself demonstrate anything of a juridical nature. Now, a similar position was taken by the court some 50 years later in the navigational rights case, where the court, relying again on state practice alone, held that Costa Rican fishermen had a customary right to fish in the San Juan River for subsistence purposes because of continued and undisturbed practice over a long period of time. Thus, the court concluded that a customary role existed because Nicaragua, like previously India in the passage case, had failed to contest the existence of such practice. It should be stressed, however, that Nicaragua, in her contentions, claimed that this practice has not become binding on it as customary law for lack of opinio juris, a claim that was dismissed, rejected, however, by the court. Now, both of these judgments are about bilateral customs, and of course, as you understand, they do not concern the recognition of a norm that could be used outside this particular context. In some other cases, however, the court has put emphasis on opinio juris rather than on the question of practice. In the military and paramilitary activities case, the court had to answer the question of whether the prohibitions on the use and threat of force and intervention contained in the United Nations Charter could be applied by the court as custom outside the Charter, since the court was prevented from applying the provisions of the Charter as a multilateral treaty because of the US reservations when accepting the compulsory jurisdiction of the court according to Article 36(2). Now, this being so, the court had to turn to non-binding texts, including the General Assembly resolution on friendly relations. As the court explained, opinio juris may, with all due caution, be deduced from inter alia the attitude of the parties and the attitude of states towards certain GA resolutions, and not from the resolution itself, of course. Now, after examining and interpreting, I would say, this text, the court concluded that a customary prohibition on the use of force exists, drawing on evidence of opinio juris alone without analyzing whether there existed sufficient state practice supporting such a customary rule. Instead, the court focused again its attention on whether abstentions by states from threatening or using force or from intervening were motivated by opinio juris, a sense of legal duty that custom prohibited the relevant actions. It is therefore obvious that the key issue for the court in this particular case was opinio juris and not state practice. Moreover, the court observed that practice needs not be in absolutely rigorous conformity with the rule. Now, as regards the question as to whether there could be a customary exception to the rule emerging from state practice, the court observed that for a customary exception to arise, not only must the acts concerned amount to a settled practice, but they must also be accompanied by the opinio juris sive necessitatis. Of course, you understand that the context of this particular conclusion was such, and the importance that the General Assembly member states attached to the principle of the prohibition of non-use of force as a fundamental principle of law was so strong that the court could not have delivered any other judgment or conclusion in this particular case. Now, what about the legality of the threat of use of nuclear arms, weapons? Now, in this particular case, the court had to examine whether there was a customary international law rule prohibiting the use of nuclear weapons. And although this was obvious that there existed a general and consistent state practice as regards this prohibition, because the nuclear states had abstained from using such weapons since 1945, the court had to prove that an opinio juris existed with respect to such abstentions. Moreover, the court in this case did not accept the argument advanced by states that an opinio juris could be derived from a negative practice alone, especially given the attitude of the nuclear states regarding the relevant General Assembly resolutions on prohibition of weapons. In this respect, the court stressed that in order to establish the existence of such a rule in a given GA resolution, it was necessary to look at the content and the conditions of this adoption, as well as to whether opinio juris exists as to its normative character. The court, after examining the relevant UN resolutions, found that such opinio juris as to the normative character of the resolutions in question did not exist, to the extent that several of the resolutions under consideration in the present case had been adopted with substantial numbers abstaining or casting negative votes. This is a very important case because the reasoning of the court is contradict actually with the new judgment of the court on the Nicaragua-Colombia case that will be analyzed to you by Mr. Papastavridis. So it should be said that the court came to this conclusion since states were profoundly divided on the matter and on whether non-recourse to nuclear weapons over the past 50 years constituted an expression, the expression of an opinio juris. So it did not consider itself able to find that there is such an opinio juris. This advisory opinion shows the ambiguity related to omissions as practice established in a customary international law rule, and how in such cases it is the opinio juris that effectively creates a supportive state practice out of inaction. Now, there are, of course, other cases, Barcelona traction arrest warrant case, jurisdictional immunities case. I don't want to get into much detail about this. What is important to see is that in these cases, the court had to examine whether tort exemption, in the last case immunities, there was a tort exemption to state immunity, part of customary international law and applicable in the circumstances of the case. But the court in this case, as in the arrest warrant case, concluded that there was insufficient practice to support the existence of the alleged customary exemptions to state immunity. However, the court itself, in this particular case, examined some relevant conventions, the European Conventions on State Immunity, and also the United Nations Convention on Jurisdictional Immunities and Their Property, not binding, which were not binding to the parties at that time because this convention, the United Nations Convention, has not come yet into force. Now, relying on this particular text, these two conventions, the European Convention and the UN Convention, the court in the jurisdictional immunities case observed that these conventions make clear that it is not confined to that matter and excludes from the scope of the convention all proceedings relating to acts of foreign armed forces. I mean, this shows how the court relies on text other than General Assembly resolutions in other relevant treaties in order to make up its mind about the existence of a customary role. Now, in the Chagos advisory opinion, the court had to clarify whether Resolution 1514 of the 60s could prove that there exists a right of self-determination as a rule of customary international law. But the key issue here was this, because the resolution itself, whether this was part of customary international law. And this was important because the court had to consider also at which point in time the right of self-determination had become a customary international law rule binding on all states. Now, the court found that Resolution 1514, passed in 60, represented a defining moment in the consolidation of state practice on decolonization, insofar as it clarified the content and scope of the right to self-determination. Further, the court emphasized that this resolution had a declaratory character with regard to the right of self-determination as a customary role in view of its content and the conditions of its adoption. So content and condition of its adoptions are very important for the court in order to conclude whether there is a customary international rule according to this text. Now, the court observed also that this finding was confirmed by another General Assembly resolution, Declaration on Principles of International Law Concerning Friendly Relations, the 2625, the number of the resolution of October 1970, which again recognized the right to self-determination as one of the basic principles of international law. So the court noted that both state practice and opinio iuri at the relevant time confirm the customary law character of the right to territorial integrity of a non-self-governing territory. Thus, the court arrived at this conclusion in terms of the applicable law in right to self-determination, concluding that this was a customary rule of international law in the midst of 1960. There are many dissenting opinions and different approaches to these conclusions. I would only quote what Judge Cansado Tridande and Robinson and Sebutinde said about the way the court concluded about the existence of a rule, customary international law on self-determination. They thought that the court could have gone even further. And in their view, the right to self-determination has been already consolidated into a peremptory norm of a jus cogens character. There are other views, of course, and many commentators have pointed out that the ICJ in this case did not actually explain how the decolonization declaration came to reflect customary international law, other than to describe it as a defining moment in the consolidation of state practice on decolonization, and also how the declaration relates to the concept of self-government, because actually these were the terms that were used in that decision, in that resolution. Now, I won't get into the Nicaragua-Colombia case because, as I said, and as you know, Papastavridis Akis Papastavridis will talk to you tomorrow. But I would like to say that some very important views were expressed, dissenting opinions were expressed, in particular by Judge Tomka, Robinson, Charlesworth, and of course, Akis will analyze all these opinions. What is really disturbing is this case that the court came to the conclusion, that there is a customary international law that prohibits states from extending the outer limits of their territorial sea within 200 nautical miles from the coast of another state. In doing so, the court, of course, as you know, relied solely on state practice again. And state practice in this particular case was not so clear. That was accompanied by an opinio juris. And of course, the judgment contains a lot of controversial remarks and has been severely criticized by many. Now, I would like simply to point out that in her dissenting opinion, Judge Charlesworth said a few interesting points, in particular with respect to the possibility of interpretation by the ICJ, aiming and articulating the legal rule to which the general practice conforms. Actually, she postulates that practice may be susceptible to multiple interpretations, and in this case, there may be several possible rules that would explain the practice. The court would then assume an active role in identifying a legal rule that would accommodate the broadest variety of practice. Thus, it is suggested that the element of interpretation by a judicial organ, of course, is introduced to the formation of customary international law. In my view, these views by Judge Charlesworth need further elaboration, and I believe that we will see how the court in the future will continue elaborating and reflecting upon these suggestions. To conclude, I would like to say that in the growing complexity of contemporary international law, the determination of the content of a customary rule as established by practice and opinio juris may be very complicated. And as you see, the case law of the ICJ shows that the evaluation of the existence of the above two constituent elements of custom is a difficult and very demanding task. And the approach followed by the court has not always been very consistent and differs, of course, according to the circumstances of the case, and also in many cases, it has taken into account nature and context of customary rule. Evidence supportive of opinio juris is also crucial for the determination of the existence of a new customary international law, and can provide valuable assistance in understanding state practice. Can I say only one word? In 2019, Judge Yusuf delivered a statement in the Sixth Committee. And I think, where is Madame Escobar? She was there at the time. Yeah, I'm sorry, I cannot see you. I'm sorry, just opposite me. I don't know if you remember what Judge Yusuf said at that time. He tried to describe in 2 words the engagement of the court with customary international law. And he used the words creativity and caution. So I want to express a hope that the court will continue to deal with these questions with the same creativity and, of course, caution that it has done until now. Thank you very much. taking more.
Thanks very much to you. Your topic is so rich. I mean, it's I think it's damning to cut and to choose and pick up what you want to say about that. But at the same time, I found very interesting that at the end of your speech, mentioning Judge Charlesworth's dissenting opinion, you directly challenged something that Panos will undoubtedly address in his...
I apologize for that.
No. Just that's really good because we can see how things are following up one on the other. Professor Panos Merkouris, who has lived for the past 5 years immersed in TRICI-Law, will now explain to us that interpretation of customary law is not a bogeyman, but an irreplaceable tool, and then we'll certainly address what you said. Do you speak about interpretation of customary law or interpretation of practice? And there is a strong difference between both, I think. You have the floor.
Thank you, Madam Chair, for also spoiling a little bit of my presentation, and as well to... I know. All 70, 80 papers. I knew I was going to be called out on that, and also to Ms. Telalian, because her very rich presentation, also in the end with the cases mentioned and the quote by Judge Yusuf as well, functions as a very nice bridge to what I'm going to be discussing in the next 15 to 16 minutes. The title, the presentation basically will deal with some of the main arguments, usually repeated time and time again against the interpretability of customary international law. However, the first problem that I had to deal with was with the title. And of course, you could start with doing research about many things about interpretation of customary international law, but the OCD in me had to figure out how to write Bogeyman. And I'm not sure if in the program and in the booklet, and that irks me to no end. I think I've written it in 2 different ways. So is it a bogeyman or is it a boogeyman? Malgosia, you're pointing? With one no. And of course, Malgosia says that because according to the greatest source, Wikipedia, Bogeyman with 1 O is the UK version. Bogeyman with 2 O's is the American version. And Malgosia teaches at Queen Mary, so of course she chose the first one. So having solved that, then the only other thing that was left was to continue with the arguments about this presentation. So with respect to this, I was inspired by Tim Burton's fantastic movie, The Nightmare Before Christmas. Also, Halloween is approaching, so if you haven't seen the movie, it's a good idea to see it. If you've seen it, of course, you're going to watch it again. And there are going to be some spoilers, so I'll warn you in advance about this particular movie. So there, the main antagonist of Jack Skellington is, well, as it proves, spoiler, is Oogie Boogie, which is basically taken from the concept of Boogeyman. So what I aim to do this presentation is tug a little bit at the strings. You will see that Boogeyman is, Oogie Boogie is basically covered in a burlap sack, but there are gaps there. And the aim of this presentation is to tug a little bit at the strings of various of these arguments and to basically demonstrate that either these arguments do not stand up to scrutiny if you look up a little bit closely, or they're basically more general arguments against the process of interpretation. And the weird thing there is that these arguments are then only presented with respect to customary international law, because nobody wants to say that about treaty interpretation, because there's a lot of cases dealing with treaty interpretation, and there would be a lot of pushback if that argument was made about treaty interpretation as such. So what are the main arguments against? So of course, let's get the first one out of the way. Customary international law is unwritten, therefore you can't really interpret it. So the answer here is twofold. So first of all, well, really that is not the case. First of all, Denis Allan in his Hague Academy lectures had a very nice word for it, that basically every rule, even an unwritten one, has a vêtement lexique. So a lexical garment. And of course, everybody's arguing nowadays that customary international law has been codified in so many different instruments. There's so many statements. Clearly, for every rule of customary international law, even deep sea mining, there is some variation, some lexical garment with which either states or other international actors refer to that particular rule. And there is no other possible way. If you're going to try and apply a rule, you must have a lexical variation, a way that you address the rule, represent the rule in judgments and practice in any sort of way. So that alone is not an argument per se. But what about also the practice of the ILC? So if you look at the practice of the ILC, you'll see cropping up in a lot of the final outcomes of its work in a lot of topics certain statements that basically, without any objection whatsoever, accept the interpretability of unwritten statements, rules, whatever you want. So with Guiding Principle 5 on unilateral acts, there is Guiding Principle 7, which talks about interpretation of those unilateral acts, but Guiding Principle 5 clearly states unilateral declarations may be formulated orally or in writing. Nobody objected to the fact that, well, if we look at our Guiding Principle 5 and 7, well, can we or can we not? Absolutely not. Accepted without any problem. Same thing with Conclusion 20. Well, not without debate, but Conclusion 20 on jus cogens. So the way that it is phrased, basically, it says where it appears that there may be a conflict between a peremptory norm of general international law and another rule of international law, the latter is as far as possible to be interpreted and applied as so as to be consistent with the former. It doesn't talk about treaties. It talks about any relevant rule. And by the way, this was an intentional switch from earlier drafts where only treaty rules were mentioned. So here, every rule is mentioned. Let's go to ILC Conclusion 6 on identification of customary international law, where one would expect, well, clearly there is no reference at all to interpretation whatsoever. It's just about state practice and opinio juris. Conclusion 6 says practice may take a wide range of forms. It includes both physical and verbal acts. And I mention this because the rapporteur himself, Sir Michael Wood, has also come out recently talking about interpretation of state practice, therefore accepting interpretation of unwritten acts as well. Unless we're going to make an argument there that we can't interpret unwritten or verbal examples of state practice, but then the whole two-element approach becomes very, very shaky because you can only choose their written and so on. It becomes very, very problematic. And of course, we have the fifth report by Escobar Hernandez, who's straight ahead, which is on immunities of state officials, which is replete with references to logical, teleological, systemic interpretation of customary rules. So you see that even in the ILC, you see some inconsistencies. You see also references to interpretation of customary rules. So the fact that it is unwritten doesn't seem to hold water. So if you tug a little bit at the string there, you see the argument kind of unraveling. Then we go to only interpretation of state practice. That we don't have interpretation of a customary rule. We only have interpretation of state practice. Now, this I find a little bit bizarre to accept. Because if you accept that you can interpret state practice, I would presume that it logically follows that you would be able to interpret the rule as well. Unless the argument is that we're interpreting only state practice. But then the problem is, why isn't really anybody talking about interpretation of opinio juris as well? Why are we focusing only on interpretation of state practice? And why is interpretation of state practice better than interpretation of a rule? Given the whole arguments and criticisms about the two elements approach with the selectivity of practice, the lack of practice, also in the case mentioned in Colombia versus Nicaragua about focusing on just a few examples, jurisdictional immunities as well, arrest warrant case. So the ICJ has been heavily criticized of being very selective in its practice. would an interpretation of a rule actually help solve these criticisms? Because then you're focusing on the rule, on an alleged rule that has emerged, but focusing on the rule rather than interpretation of specific elements of practice, which then simply continues the same problems that you already have with a two-element approach. And another argument that I still have to find an answer is, well, if we accept interpretation of state practice, then by necessity you accept that you look at the object and purpose of that. If you don't have that method of interpretation, you really can't be talking about interpretation of state practice. But then the object and purpose of what? Is it the object and purpose of one element of practice? Then nobody really cares, at least for the purpose of the rule. Is it a few elements? But then wouldn't you have to look also at the object and purpose of the opinio juris? Unless the argument there is, and that is sometimes proposed, that you're looking at the object and purpose of the totality of state practice and opinio juris. But then that's no different than looking at the rule, because you're looking at the elements that constitute the rule. So you can't separate the object and purpose of one element, because that cannot necessarily reflect the entirety of the object and purpose of the rule. And if you go for the entirety, then you're talking about the rule. So that is the problem that you have there. Two additional ones very quickly is that, don't get me wrong, I understand the distinction is difficult. It's not always easy to draw the line. But I usually refer to the Sorites paradox, that basically everybody knows what a hill is, but if I ask you when exactly it becomes a hill, nobody has a specific answer. So this is the same thing about sometimes where the identification and interpretation of customary international law, where the line is divided. But you could say the same thing also with treaty interpretation, when you're talking about interpretation and modification, where exactly the line is drawn, and Malgosia will deal with this in much more detail and much more informatively than I ever could. But the conflation of the two processes, you can see it also again in the work of the ILC. So in Guiding Principle 7 on unilateral acts, it says a unilateral declaration entails obligations. I have 5 minutes for the audience to know. In the case of doubt, as to the scope of the obligations resulting from such a declaration, such obligations must be interpreted in a restrictive manner. And then it continues, when interpreting the content, then basically you kind of apply the rules of interpretation in the VCLT. Now, here, this seems a little bit bizarre, because whereas in the discussions in the article, it seems that they say, okay, you apply mutatis mutandis, the rules on interpretation of interpretation. The second sentence basically promotes an indubio mitius, a restrictive interpretation, which goes against the very idea of interpretation with treaties and generally rules of interpretation. And you see the difference there between the terms scope and content. And I think the reason for that was because the ILC kind of adopted the language by the ICJ in nuclear tests, which was very similar. But the only way to make this work, to say, well, we apply the rules of interpretation, but we first go for a restrictive approach, is if you say that the first one is about identifying whether a rule exists, in which case, yes, it makes sense to go for a restrictive interpretation or a restrictive approach, let's be more clear, because it's about identifying whether a rule exists. And once you've identified it, when you want to determine the content of the rule, you go with a proper approach on interpretation. Similar considerations with the ILC draft conclusions on CIL identification. So in conclusion 3, there is a reference that in assessing evidence of state practice, what you would do is look at a lot of other things, but regard must be had to the overall context. And in the commentary, this is clear that basically it means a version of the principle of systemic integration. You look at other relevant rules. And again here, this seems to me at least an indication that this is a little bit of a conflation with respect to the two processes. Because looking at the relevant rules and from that determining the content of the customary rule is an element of interpretation, not an element of identification. I'm almost done. So another argument there is that courts have rejected customary international law interpretation. Now, if you ask any philosopher, they will tell you that trying to prove a negative, good luck with that. And basically, what the project is trying to do is say, we can interpret customary international law, and the argument against it is, no, you can't. So the onus probandi is on the other side. But leaving that aside, if you look at the project and the 70 pages, Hélène, there, you'll see that it is not just writings of other academics that we've looked at. It's actual practice of international and domestic. So actually what would be considered as state practice in order to identify customary rules on interpretation of custom. So, and even the courts that reject this, if you look at the judgments, you'll see that they don't reject interpretation of customary international law as such, but they reject that particular interpretation because it leads to a modification of a rule, which is perfectly understandable, and it is a limit of interpretation anywhere you go. And this is one of those rare instances, because Sir Michael Wood, writing about interpretation of state practice, mentioned two cases. One of them was a Greek case. I'm not sure whether that was intended as a kind of a nod to the Greek guy talking about interpretation of customary international law, that a Greek case says no, 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 no. But the problem is that there was a bad translation of that case. If you look at the actual Greek document, you'll see that the relevant part basically says you cannot arrive at that particular interpretation from one particular principle alone. And even in the civil code, there is an understanding that there is possibility of interpretation of customary international law. 1 minute? Perfect. So there are also, finally, doomsday scenarios and a little bit of double standards. So one argument, and this was also raised recently in an EGIL talk post, which, well, became infamous for all the wrong reasons. I will not continue on that. But basically the argument there was that customary international law interpretation creates new law. No, it doesn't. It's regular interpretation. If you have a problem and if you think that interpretation generally is lawmaking, that is an objection to interpretation in general, not customary international law. Again, if you tug a little bit of the arguments, you see that they don't match up to scrutiny. And CIL interpretation authorship basically focuses only on academic writings. As I said, it's not that. It's a lot of state practice and opinion juris. And in fact, the funny thing was that in that sentence, the blog referred to Sir Michael Wood's blog. So they did what was being criticized, in which the wrong case was being mentioned. So the final point that I want to make is, what is interesting is when we're talking about interpretation of state practice and when we're talking about the fetishization of state practice and opinion juris as two elements, then when we discuss customary international law interpretation and we present state practice, opinion juris on the matter, in that particular instance, for some bizarre reason, that particular state practice is absolutely irrelevant for those who argue only on the basis of state practice and opinion juris. And what we're saying is that there is sufficient state practice, sufficient international practice. States themselves also in a variety of documents have clearly talked about interpretation of customary international law, and therefore this should be taken into account when we're discussing. Final slide. The questions on the delimitation of the continental shelf. Yes. We're not going to spoil it for Dr. Papastavridis, but we've been spoiling it quite a bit. No. The only thing that I'll say is Charlesworth indeed talked about interpretation of state practice, although she qualified it as evaluation, which I do think makes a difference. And she talked about interpretation of a customary rule per se. What is interesting is, and that's all I'm going to say, is that this case demonstrates why there is need for methodological rigor when we're talking about either identification or interpretation of customary international law. And that's why we're having this discussion, to be able to properly have the necessary language. So, oogie boogie. Final sentence, I promise. It's going to be a long sentence. So, oogie boogie was the main antagonist. And I kept saying we tug at the strings. The reason is, spoiler for the end of the movie, is that Oogie Boogie eventually is vanquished because Skellington tugs at the string. And then what it appears is that behind it there is nothing. It's just insects, and Oogie Boogie dissolves into nothingness. So that's why I try to present here, is that the arguments against interpretation of customary international law sound like also themselves as a boogeyman, so not the interpretation, but the arguments against it. But if you look at them closely, if you put them under scrutiny, you realize that they really do not hold up to scrutiny, and therefore, if you're going to object to CIL interpretation, other arguments need to be found, or the easiest way and the correct way is to accept that customary international law can be interpreted. Thank you very much. Sorry for going beyond the time.
Thank you very much for that. You have put a nice pressure on the panelists for the next panel. So, but I will leave at that. And I'm happy to give the floor now to Professor Malgosia Fitzmaurice, who will speak about customary international and the interpretation of treaties beyond the 1969 Vienna Convention of the Law of Treaty. So you have the floor.
Thank you very much, Madam Chair, and also thank you for inviting me. And obviously, Panos, as an old friend, gave me a really tricky question to deal with. Tricky, because we all know that the Vienna Convention from 1969 is a codification of customary international law. So basically, he put me in a position of coming up with something new, something which goes beyond Vienna Convention, relates to the treaty interpretation, and also is perhaps customary international law. So what I'm going to present today, it's more speculation, more question marks than very final saying this is customary international law. I am just putting some question marks, some proposals, some really maybe even fancy ideas, but I think they are worth proposing, also because it relates, as we already heard many times, work of the International Law Commission, and in that instance of my presentation, I will draw on the report of Judge Nolte now and the draft conclusions on subsequent agreement and subsequent practice from 2018. Probably not a very well-known work of the International Law Commission, but I studied it and I find it really worth bringing to the attention of today's conference, also as a, I would say, ground for further discussion. And again, I want to say that my presentation will be more questions and more speculation than strict answers. So I will not analyze in my presentation the scope of Article 31 of the VCLT, because it is beyond Article 31, which, as we all know, is a codification of existing customary international law. I will also leave alone Article 31(3)(c), because I think Panos Merkouris already said everything what it was to be said about it. And anyway, it is a well-known principle of integration. So I will completely leave all these questions alone. And my presentation, as I said, will be mostly based on quite unknown conclusions of the ILC draft. I found actually in preparation for my presentation quite interesting comments and quite forward-looking of Judge Villiger, who wrote about customary international law, and he, I think, made a very progressive comments that customary international law may serve as supplementary meaning for conventional norms, not originally envisaged by the treaty drafting body. So this is already one instance foreseen by Villiger in which customary international law is reaching outside the treaty text. So, and the second instance, when the underlying customary rule, forming a part of a written framework, may change. So again, a very forward-looking idea, which we may say later was developed in evolutionary interpretation of treaties, and a principle which also, in my view, goes beyond Vienna Convention. And I will say, time permitting, 2 words about it, time permitting. So, in analyzing customary international law beyond the Vienna Convention, I identified 2 approaches, a formal and a substantive. So a formal approach can be found in situation when parties to the dispute before international or national courts are not parties to the Vienna Convention, nonetheless agree to apply Vienna Convention on interpretation as the already customary codified principles as customary international law. And that was the case of Kasikili-Sedudu Island, and this case will also form part of my further presentation. Not a very well-known case again, but very instructive from the point of view of interreaction between treaties, customary law, and beyond, and customary law, in my view, beyond treaties. So the second identified by me instance of customary law beyond, interpretation of treaties beyond customary law is the substantive forms of application. So I identified 2 possible scenarios. So the modified rule of interpretation already included in the Vienna Convention, and this norm was already established as customary international law, but it goes beyond and it's modified, and can be said that it's in process of maybe crystallization of a new norm. So one of the instances of interreacting between treaties and customary international law, also identified by Sir Michael Wood in his report 3 on treaties and customary international law. And the second example is evolutionary interpretation. So now, let's go back to modification of the rule of customary international law of treaty interpretation, which already finds its place in the Vienna Convention, however it's modified. And this is a situation which was foreseen by Professor Nolte in a draft from 2018 on subsequent practice and subsequent agreement. So this is supplementary means of interpretation. And the supplementary means of interpretation obviously is a norm of customary international law well established in Vienna Convention. However, we have now in draft conclusion 4, paragraph 3, subsequent practice as supplementary means of interpretation under Article 32 of the Vienna Convention. This is supplementary means of interpretation which does not hinge on practice of states, but rather refers to travaux préparatoires of the convention. So it says as follows: a subsequent practice as a supplementary means of interpretation under Article 32 consists of conduct by one or more parties in the application of a treaty after its conclusion. And now something which I would really would like to emphasize. This is absolutely new type of subsequent practice. This is not subsequent practice provided for in Article 31(3)(b). But this is the practice which hasn't still matured into the practice provided by the Vienna Convention, but all indicates to some extent a subsequent practice of states and doesn't reflect the agreement of all the parties, but can serve as an auxiliary means of interpretation. Again, Kasiliki-Sedudu case comes into the rescue, where actually the court applied this possibility in relation to 1890 treaty between Botswana and in the parties between before the court, and said that the practice of the states does not, it's not consistent, it doesn't reflect the agreement of the states. However, it takes into consideration in order to specify the provisions of a treaty. So this is something which I would like to give for consideration. Is it already this new subsequent practice in Article 32 Customary International Law? Is it going beyond the law of the Treaties Convention, or is it in the process of crystallization? So I think this is a very interesting question, and this application of subsequent agreement and subsequent practice is not very well known. However, it was picked up by the International Law Commission as something which court already applied. So maybe it is some norm of customary international law going beyond the Vienna Convention on the Law of Treaties. So also, I would like to turn attention to draft conclusion 5 in the International Law Commission specified the other conduct. So the other conduct of non-state actors, but other actors, which may be useful in assessing subsequent practice in application of the treaty. Again, some innovation, again, some new approach, and again, question mark can be put, is it already matured rule of customary international law, or is it only in the process of crystallization? So I think I have to push on. I see the chair, Madam Chair. So now I would like my last part of my presentation, 2 minutes, will be on evolutionary or evolutive interpretation of customary international law. This is also going beyond the 1969 Vienna Convention. So obviously, we all know about classical application of the rule treaty as a living instrument, which was introduced by the European Court of Human Rights, and later even made more sophisticated through, in my view, inclusion of philosophical and ethical approaches to European Convention. So the approach of European Court of Human Rights is not only based on the letter of law, but also includes philosophical and ethical approaches to treaty interpretation. So this is one part of, is it customary international law? Obviously, evolutionary interpretation was already used in many other interpretative efforts, and even in conclusion 8 of the 2018 draft of the International Law Commission, conclusion 8, subsequent agreement and subsequent practice under Articles 31 and 32 may assist in determining whether or not presumed intention of the parties upon the conclusion of the treaty was to give a term used a meaning which is capable of evolving over time. So this is basically a question of interpretation over time. But there are lots of unresolved questions which still pertain to evolutionary interpretation. Is it depending on character of a treaty? So human rights treaties, it's a very good example of a treaty which can be subject to evolutionary interpretation. What about other treaties? What about treaty, only generic terms of a particular treaty, like il commercio in navigational rights case? Is it only one generic term of a treaty which can be evolutionary interpreted? Then very important, intention of the parties. Have the parties intended to give a treaty possibility of evolutionary interpretation? Gerald Fitzmaurice, who was a judge on the court, he thought that this is going against the principal rule of treaty, consent to be bound, that states want to know to which they consented. However, the counter-argument is the character of a European Convention as a human rights treaty. Then interpretation versus modification. Again, we are not quite sure how evolutive interpretation is posted vis-a-vis interpretation, modification, amendment, and subsequent practice. And all this came to discussion in navigational and related rights case in 2005, where the court was grappling with interpretation of the word il commercio. And it was a division in the court. Is it evolutionary interpretation or subsequent practice? And how can it go? So this is the main question. How far can it go? And there is absolutely no consent in the theory and doctrine of the law of treaties. Some authors claim that the subsequent practice and subsequent agreements can go further than evolutionary interpretation from the letter of a treaty, as Irina Buga in her book expounded, but also there is totally different view that this is within the square corners of a treaty, subsequent practice and subsequent agreement, and evolutionary interpretation go further. So again, a clash of different views beyond the Vienna Convention with many questions unanswered. So my conclusions, more questions than answers, and very diversified practice in relation to subsequent practice and agreement as part of Article 32, so not as classical, not as classical formulation in the Vienna Convention, and gray areas between the division of the elements which I was just talking about. So is there opinio juris already? Is judicial practice sufficient to expound the theory that it is already customary international law beyond the Vienna Convention? Thank you.
Thanks to you, indeed, we have realized that on this topic we really need to identify the good question. And one of the questions you raised, identification versus modification, is a long-lasting one that Dr. André de Roux, I don't know exactly how to pronounce the name, sorry if I don't pronounce it well, will tackle and try to separate the wheat from the chaff.
Good afternoon, ladies, gentlemen. As you may have been able to see from the title of my presentation, I'm concerned with the distinction between interpretation and modification of customary international law. And this goes to the draft articles on the interpretation of rules of customary international law just sent round by Panos, where Article 10, paragraph 2b indicates an interpretation of a rule of customary international law may not lead to a modification of the rule being interpreted. Now this, of course, puts down the petitio principii, namely that there is a distinction between interpretation and modification, and that therefore there must be some ways to actually separate one from the other, therefore separating the wheat from the chaff. Now, of course, that particular biblical expression is used often to separate good from the bad, with the wheat being good apparently and the chaff being bad. We know now, of course, that chaff actually is the more healthy part of grain, so it's not quite the case that modification is bad per se. And as we shall see later on, there are a number of examples where obviously customary international law has changed. You could call it even modified, and therefore it's not that I'm against modification per se, but if you kind of put the principled position there that there is a difference between the two, then it should be possible to operationalize the distinction, and that, I think, is far more difficult to do. Now I will first talk a little bit about the interpretation of treaties, because basically, of course, we compare everything to interpretation of treaties when we think in terms of interpretation. Then some observations on modification of treaties, which has been contentious as well, at least on the particular point of modification by practice of subsequent to the treaty. And from there, I'm going to go to customary international law. I won't say much on identification. I have put on the board a quotation from the Nicaragua case, where the court comments on the issue of modification. And that's, of course, something I'll get back to. Now, when we look at the interpretation of treaties, there are a number of points which provide a framework. And the first point in that respect is that the intentions of the parties is what we're looking for. Now, of course, that particular expression is a bit problematic, because the text of the treaty is not actually made by the parties, but rather by the negotiating state, who may or may not become signatories and who may or may not become parties. But, you know, there's a kind of idea apparently that if we have the intentions of the negotiating states, that will turn into the intentions of the parties. And that's kind of a baseline. So the idea is that we kind of want to establish what states actually had in mind when drafting the treaty initially. But that leads to the second point, which is that the International Law Commission has said in the commentaries that the text of the treaty is the authentic interpretation of the intentions of the parties. And therefore, the idea is that when we interpret the text of the treaty. We do not necessarily go back to the preparatory works and the negotiating history to see what each individual state may have had in mind. Of course, we can do so under Article 32, but you know, that is in principle supplementary and depending on a choice whether to use it for confirmation or whether to use it for determination if the text is unclear or ambiguous or leads to an unreasonable result. Again, that gives a certain frame, of course. In principle, we have to interpret the text of the treaty. and if words are to mean anything, there must be limits to what they mean, because otherwise, you know, we don't really need a process of interpretation if we can just make it seem as anything goes. That was kind of something which Humpty Dumpty used in his famous expression that the issue is only who is master of the text and therefore of the interpretation, and therefore he could make words mean anything. But of course, we communicate through words precisely to give meaning, and to give meaning is also to have inclusion and exclusion within that meaning. Now, from this particular point, then we go to the next one, which is that, as the International Law Commission put forward in the commentaries again, the process of interpretation is supposed to lead to the legally relevant interpretation. Panos uses the word the legally correct interpretation, but in any case, it's supposed to lead to one interpretation. It uses the article the, not a. If it had used an interpretation, then it could mean any kind of interpretation, but because it's the interpretation, it must be one interpretation. And if you look at the way in which Article 31 especially is structured, the whole point is to move from one element of interpretation to the next element of interpretation, and in this way to limit the number of interpretations that may possibly result from our inquiry, and in that way eventually simply end up with one interpretation that would then be the legally relevant or the legally correct interpretation. Now, of course, this is somewhat controversial. There are people who say that the process of interpretation is about establishing a frame of interpretations, but of course, if there were multiple interpretations possible, we're in a difficult situation, especially when we think in terms of adjudication, because how are we going to choose then? If, you know, one interpretation is as good as another interpretation, how are we going to solve disputes? Of course, we could go for the Article 17 anti-dumping agreement in the WTO agreement, namely to say that there are multiple permissible interpretations possible, but that just complicates the whole process altogether. But all these points are relevant in the sense that apparently we have an idea of this process of interpretation leading to one interpretation, which suggests, of course, that if we go beyond this one interpretation, we might end up in modification. That's kind of the idea of putting forward these kind of things. Now, many authors, of course, have referred to the commentary referring to the crucible of elements of interpretations in the context of treaties. I don't like that particular part. I think it's wrong as a matter of law to say simply, well, we're looking at all the elements of interpretation and the right one will simply kind of follow from it. We mix it around a little and then at some point, for some reason, logically, we end up with one interpretation. That, of course, goes to the other comment that there is no hierarchy of the elements of interpretation, something which the ILC said especially because the United States didn't like the weightings which you saw in the text. And I think these weightings are important. The weighting that you see in Article 31 in paragraph 1 is that interpretation shall be in accordance with the ordinary meaning in context, not in accordance with the object and purpose. So basically object and purpose is a kind of auxiliary means to choose between ordinary meanings in context rather than to have an independent meaning. Now that is just as well because teleological interpretation basically throws out many of the elements of interpretation if you don't take them into account as well. Okay, these are just some thoughts here. Now how about modification of treaties? Now, technically, of course, there are a number of ways in which modification can take place. In the Vienna Convention, you see this by reference to reservations, which modify the legal effect of provisions, modification of obligations or rights of third states, amendments, modification between certain of the parties to the treaty only, and modification of peremptory norms. So these are a number of provisions where modification is envisaged. However, crucially, one particular way of modification, namely by subsequent practice, was proposed by the International Law Commission in its draft articles, but was thrown out at the Vienna Conference in 1968. Basically, the states negotiating didn't like that option. They disliked it for various reasons, not only for principled reasons, but the International Law Commission had a provision on this. Now, the difficulty with looking at subsequent practice in the application of the treaties as a matter of interpretation or subsequent practice as a matter of modification was that the provisions were pretty much identical. The text was almost the same. The only difference that you could detect was that, of course, for interpretation, there was reference to the agreement of the parties, which was the same in the text for modification, but in the commentary to the modification provision, it talked about change by common consent, as if a consent construction was required. But how that would be different from establishing the agreement of the parties in the first place was, of course, not really indicated. Now, we know, of course, that interpretation should not lead to modification, also because the ICJ has actually said so. I think it's in the advisory opinion on interpretation of the peace treaties, where the problem was that a procedure for choosing arbitrators was faulty. There was no eventual rule for choosing when the parties to the dispute didn't actually cooperate in choosing the arbitrators. So this was a gap in the procedure. And the court said, well, the task of the court is not to revise treaties, but only to interpret them. And the court rejected the idea that we could kind of fill in this gap in a different way by letting the president of the ICJ choose an arbitrator instead of following the procedure as set out in the peace treaties. So that's what we kind of know. Interestingly, and Panos of course refers to it also in the commentary, draft conclusion 7, paragraph 3 on subsequent agreements and subsequent practice indicates that it is presumed that the parties to a treaty, by an agreement or a practice in the application of the treaty, intend to interpret the treaty, not to amend or to modify it. Now, Panos, I'm going to chastise you a little bit. You're quoting this, and quite correctly so, but you're then omitting to actually give the next sentence, which is the possibility of amending or modifying a treaty by subsequent practice of the parties has not been generally recognized. So this is kind of the point. Can you actually modify a treaty by practice or not? Now, let me give you one example where this has actually happened, and that concerns Article 27, paragraph 3 of the Charter of the United Nations, which concerns the voting procedure of the Security Council, where it indicates that on non-procedural matters, decisions shall be taken by an affirmative vote of 9 members, including the concurring votes of the permanent members. Now, the ICJ addressed this in the Namibia advisory opinion, kind of implicitly interpreted the provision to mean that abstentions by permanent members are not vetoes, and because they are not vetoes, they have to be considered concurring votes, but that, in essence, is an interpretation contra legem. If you interpret Article 27(3) properly, then a concurring vote would have to be an affirmative vote, and it's very obvious that an abstention is not an affirmative vote. Now, the court justified this by reference to the general practice of the Security Council, rightly so, and by reference to the general agreement of the members to this practice, again, I think rightly so, but of course it never made clear whether it was supposedly interpreting Article 27, whether it was modifying it, and whether it could do so considering the fact that the amendment procedures of the Charter were not being used. So this kind of shows the difficulty. The court certainly has, I think, engaged in modification in this case, which kind of supports the idea that modification by practice is possible. But in the ILC, of course, this turned out to be not so easily accepted. So going to modification in customary international law. So moving to the topic of our current presentation. Let me note, by the way, of course, that I will fully conform to the directions of the chair on time issues. And if I, I'm not able to say certain things, that's just how it is. Now, as mentioned, the draft articles on the interpretation of rules of customary international law, Article 10(2)(b, say that an interpretation may not lead to modification of the rule being interpreted. But my concern is that there is very little, except for the principled position here, to operationalize it. So the question is, how do we determine whether something is interpretation or modification in the first place? That is my concern. Now, if we want to see, of course, whether customary international law can be modified, the answer is clearly yes. We've seen many examples in the past where rules have been changed. Let me give you a couple of examples. One which I know Nina Mileva has mentioned in her PhD is, of course, the change of the rules on state immunity from absolute to restrictive, which, by the way, I think is still going on because, I mean, it's a long-standing development. But only this year, China has actually changed its law to account for restrictive immunity instead of absolute immunity. So it's not actually a process that had ended yet. But clearly, if you start from a rule applying an absolute immunity, then, going to a restrictive rule is a change. That's clear enough. Similar kind of things you can see in the law in the law of the sea. The Truman Proclamation, as it stood, of course, was contrary to the freedom of the high seas, because all of a sudden we see the United States claiming a continental shelf, which, under the rules of the law of the sea regarding the freedom of the seas, would be open for exploitation by all states. And if I may say so, if you take a look at the quotation, the Truman Proclamation is a kind of example where you see a claim being made by one state, which is then shared in principle by other states. So, within 13 years from the Truman Proclamation, the Geneva Conventions on the law of the sea accepted the idea of the continental shelf, only 13 years, and clearly, all coastal states were interested in accepting this. Landlocked states were probably not considered very important in this respect because they are not specially affected states and therefore, are not really that relevant, was the idea. Of course, they were later on when you look at the changes in 1982. So that's another example. Similar example you see kind of based in Libya, Malta, and Italy, Malta, where you see changing the freedom of the seas for the purposes of the exclusive economic zone, which was, of course, based on the ongoing negotiations in the third conference on the law of the sea, where states had already kind of accepted the creation of this new zone and was also accepted notwithstanding, the existing rules not really accounting for it. So we see these kind of things. Now, one of the things which is typical, of course, is that you can only modify something if something is already there. There must already be a rule of customary international law if you want to modify it. If there is no rule yet, then we're talking about identification, analyzing state practice and opinio juris to see whether that rule exists. So that's the first thing. Secondly, when rules already exist, often state practice will constitute, state practice diverging from the rule will constitute breaches of the rule. This is something which Anthony D'Amato in his book on the concept of custom already indicated in the 1970s, namely changes of rules of customary international law may result actually from breaches of the rules. I think we're getting very close, so let me just say a little bit about the operationalization very briefly. If we want to operationalize the distinction between interpretation and modification, we need to have a baseline and we need to have certain clarity on which elements of interpretation should be considered dominant or weightier than others. In the law of treaties, ordinary meaning in context, as far as I'm concerned, is the limiting frame. All other elements of interpretation must be used to try to establish which interpretations fall within ordinary meaning in context. If you take a different position, then you're necessarily transgressing from interpretation to modification. So that is my initial kind of suggestion. But you need to also get clarity. Are we looking for one interpretation, or do we accept the frame of interpretations? Of course, as Panos said in his previous document, even with a frame of interpretations, there are external interpretations which will transgress into modification. So even then, there is a limit, but operationalizing the limit will be very difficult. Now, as I said tentatively in my abstract, in principle, an irregular interpretation should not be permitted and should only be considered to modify a rule if it is bolstered by a renewed analysis of later state practice and opinio juris. Otherwise, you know, it's a free-for-all, as Jean d'Aspremont said in one of his publications. It's a dance floor where anything goes, and you know, we basically have no limits to interpretation. Okay, thank you for your attention.
Thank you very much indeed, and that could be a good question. Do we need to operationalize the distinction between interpretation and modification? I think it's a challenge of power relationship, and sometimes trying to openly operationalize could raise issues of power, and especially power of judges. So we might explain, we might understand why these issues remain somehow not formalized. But the floor is open because our speakers, unfortunately, Dr. Telalian has had to leave now, but the floor is open for questions or comments you may have. We have some 15 minutes, I understand, and there might also be questions coming from the chat. So any question from the room or comments? If you could introduce yourself for the sake of people being online, they might not see you, so thank you very much.
Good. My name is Marcel Bruce. I'm from the University of Groningen, a colleague of Panos and André. I have, in fact, a very general question. I'm not so much in the technical details of Article 31 EC. Bit better? Okay. I have the question, and that's in fact also since the beginning of this project, which I saw from the inception. Oh, you don't hear it very well. Okay. The question is really, sorry for that. The question is really, and now I have to, why are so many lawyers afraid of talking about interpretation of customary international law? What is, in fact, the real reason for that? We can talk about lots of ways we can interpret or we cannot interpret, how we can separate modification from interpretation, but there's a very much a resistance to that. And I wonder a bit why that is, and that especially a question to Panos and Malgosia, I would say. I can speculate, let me speculate what my answer is, because if you really go into the details of this and you would allow that, it would uncover a lot of the myth of and the mist of customary international law in general. So the whole concept of customary international law becomes challenged when you talk too much about interpretation. That's my speculation, but still I haven't had that answer.
Thank you very much for your question. I was going to spontaneously give the floor to Panos because he has lived with this type of question for 5 years, so he deserves a few minutes to just exhaust this. And also, I would ask just a quick question related, which is a linguistic question, for example, because in English you will read very often, you will hear about interpretation of facts, for example, whereas you would not say that in French. You will speak of qualification des faits. So there might also be a misunderstanding about what we are talking about when we speak about interpretation, depending on the language we use. So I just add this on your plate for this last moments. And so I give you the floor, and then Malgosia. Yeah, of course.
So thank you, Hélène, for allowing me to get this out of my system for now. Then it fills up very quickly again. I'll reverse it a little bit because you indeed mentioned qualification. And basically, if you see it at the articles, we use two terms, evaluation, qualification. And I have to give credit where credit is due, because you basically told me that when we were in the ILA study group on content evolution on the rules of interpretation. You had a conversation with Laurence, I think, Bourgogne-Larsen, and basically there you kind of said, oh, no, but in France we're talking about qualification, not about interpretation. And this stuck with me, and I do agree that it is also about language and the training that you have and the way that you perceive. And this ties also with Marcel's question. And this was, unfortunately, I rushed. That there was a final image in the presentation that I had, which is known as the Worf hypothesis. Those of you who have seen Star Trek, not that Worf. It's about linguistic relativity, and the idea is basically that the language itself that you use informs the way that you see the world. So perhaps in the French language, in the French legal system, there is a different way to see these things, and that's why it is easier to see these things in a particular way. Exactly. I would say also another example that I tend to use is the Einstellung effect, which is basically that people tend to get trained very, very quickly in thinking in particular patterns. And there's a wonderful water jug experiments, the Luchins and Luchins, highly recommended. I torture my students every year with that experiments just to demonstrate how quickly they can be trained into thinking in one particular way, whereas there are better other ways, easier ways, and the mind is very difficult to switch. And I think that is one of the reasons with respect to that pushback, the original pushback against the idea of interpretation of customary international law, in the sense that even if it is a blanket that is full of holes, that is so used that it is basically does not provide you any warmth, people will still prefer the devil they know and the bad blanket that they have, rather than actually seeing if there is something else there. And the reason why I can speak only for myself, so strongly believe in this idea of interpretation of customary international law is that despite the fact that every student is trained from the first year to think North Sea Continental Shelf case, state practice and opinion of jurists, this is immediately Pavlovian response. If you look, first of all, in that case, there are references by Judge Tanaka that there is logical and teleological interpretation of customary international law. So the reason I feel so strongly about it is that despite this conditioning, still you see it everywhere. If you start looking in that particular way, then you start realizing all these inconsistencies, all these hidden assumptions in documents which have never raised any objections, but the underlying premise is accepting interpretation of customary international law. And the most important thing is, and I cannot stress this enough, that states themselves, be they courts, be they states, especially nowadays when they have all these white papers about application of IHL principles in cyber context, about collective measures, where they clearly and unequivocally talk about interpretation of customary international law, still there is a little bit of pushback. I tend to be optimistic in the sense that the same thing happened when we were discussing about treaty interpretation with all the various draft codes, which if you look at them are all over the place. And then you had the VCLT, and then everybody kind of agreed on a language and started discussing that. And ILC talks about subsequent practice and agreements, as Malgosia has said. So that is what TRICI-Law, what we're trying to do is shedding a light on this, that look, there are other things. They make more sense they're actually supported by practice. There is nothing that is against it. We're used to interpretation from treaties, so we're used to the language. It's not a new language. And it may be beneficial, may solve some of the problems that customary international law already has. Whew. Thank you very much.
Thank you very much. I give the floor to Malgosia to answer as well.
Well, my intervention or sort of dialogue with Marcel will be probably less emotional. But I have to say that why the fear? Fear of interpretation is not only customary law. I think that is a general fear of interpretation, even relating to treaties. And I would say that the reasons are legal and political. Political. States fear that interpretation may raise more obligations stemming from a treaty customary norm to which they didn't consent. So they are very, very cautious in interpreting some rule which they thought they agreed. So this I would say political and legal, because it's a mess, I would say. Even in relation to VCLT, we really don't know how to interpret a treaty. And the discussion within the Law Commission is a very clear evidence. So that was a group to which Sir Michael belonged, for instance, that we already talked about elements of treaty interpretation, where all elements are completely the same, taken into consideration this crucible. I don't like it too. Method. But then Direct-Lady wrote very powerful blogs he said, I disagree with the whole group. We always look at the text, and the text is the leading element of treaty interpretation. So although it's all nicely set out in Vienna Convention, actually it's still absolutely unclear. The same intention of the parties. So we know that the text reflects intention of the parties. Really, I am not sure, and it's always a discussion. And the Bahrain-Qatar case is a very good example of it, where it was a powerful dissenting opinion of Judge Webel, who said that intentions should be treated as intentions, not only in the text, but what state really wanted. So he was proponent of really giving a more prominent role to travaux préparatoires, and the court rejected it as fragmented, not really important. So the fear, the legal and political fear, there is no firm ground still where to stand on treaty and customary law interpretation. So we really don't know what is important, what is not, and what the court is going to decide, because there is no rule. Thank you. I had it too.
Martina Radaki.
Thank you. My name is Martina Papadaki. I'm a researcher here at Bogeyman University and the Athens PIL. Thank you all for your presentations. They were excellent. I will zoom in a particular thing from raised in Professor De Hoof's presentation, and then I will try to link it back to a more general theme to ask the question. So in the Namibia case, you mentioned Article 27, Paragraph 3, and you said that it was a contra legem interpretation that essentially was a modification of the charter. And I'm wondering whether, and looking back again to the decision, actually the court based its decision not really on that aspect, that is, whether the treaty has been, the UN Charter has been modified by the actions of the parties, but rather because the Namibia case was raised not as a dispute, but as a situation. So the interpretation was based on the voting, not really on it being a modified practice, but rather it wasn't stated as a dispute, so the rule doesn't apply per se. So in two paragraphs after the paragraph that you cited, it was mentioned like that. So my general question is whether, and then again looking at the Kazakilise Dudu case between Botswana and Namibia raised by Professor Fitzmaurice, You can also see there is a long discussion about subsequent practice and subsequent agreements. And then you have the court, after discussing about correspondence and maps and exchanges between colonial powers, that actually there hasn't been a subsequent agreement because there has been no agreement. So my link to the general theme is there a fear about actually confirming modification in the first place? So the court would be more reticent and more reluctant. It will tend to find there was no modification. We can do an obiter saying, you know, it's important, and there has been a change in the charter, but actually it will base it on firmer ground. So thus confirming the whole fear about, because it's based on political and other legal fears. Yeah.
Thank you for the question. Of course, the Charter uses situations and disputes, but I don't quite see the relevance to the voting procedure. Irrespective of whether something is a dispute or a situation, usually to be seen in Chapter 6 of the Charter rather than in other chapters, the voting procedure doesn't distinguish between chapters. It distinguishes between procedural issues in paragraph 2 and non-procedural issues in paragraph 3. So I don't quite see the relevance on the issue of the interpretation of abstentions as not constituting a veto, and implicitly saying that abstentions apparently must be considered a concurring vote, because otherwise it wouldn't fulfill, you know, the conditions of the voting procedure. So I don't quite see the relevance. I'll look up the paragraph that you mentioned, 2 paragraphs after, I think it's paragraph 22, yes, so 25, okay.
Thank you very much. We will take the questions from the chat now, please. I have to balance questions.
We have a question from Ricardo DiMarco. He would like to know what the practical relevance of the interpretability of customary rules might be. Could it have something to do with an increased stability of the system and an increased stability of international courts and tribunals? Should I go on to the other 2 questions? Okay.
Yes, please. I think we take all the questions in a bunch, and do we have in the room one more question? Please, yeah, bundle the questions.
Diego Mejia Lemos. My question concerns Panos' points on interpretation and identification being conflated by the ILC in the conclusions on CIL identification by the reference to the principle of systemic interpretation. Is comparison between the content of a CIL rule in formation/being identified and the content of other rules to which systemic interpretation points part of the process of determining the normative scope and content of the rule in order to establish the norm-creating feature of practice as formulated by the ICJ in the NSCS cases, which makes it general practice. And then lastly, from MD Tabish Ekbal, ILC in its draft articles on the identification of customary international law says that practice of international organizations can also contribute to the formation of customary international law. How do we determine the practice of international organizations for the purpose of customary international law, as the juridical nature of international organizations and states are not the same?
Thank you very much. These are long questions to which I will ask for short answers. So giving first the floor to Panos.
Mm-hmm. With respect to the first question, what is the potential utility? To be honest, I don't like that question because it's, why is it useful? The research is not why is it useful, is it there? And then we'll figure out whether it is useful or not. So from an academic research perspective, I would say it really doesn't matter. But on the flip side, and serendipitously enough, it is useful. And it's not only for what Ricardo basically said is not only to ensure better legal certainty, it's also to make the argumentation, the reasoning better. You could easily compare the judgments of the courts before the VCLT, where it could go all over the place. Now, it still goes all over the place, but you at least have a solid basis on which to criticize the court. So it engages better conversation, and to be honest, it keeps judges a little bit more honest. Not too much, but small steps, baby steps every time. As for utility, I would also say that one of the criticisms for customary international law is with the third world not being involved in the creation of customary international law interpretation can help resolve that. All the arguments about the selectivity of state practice, which we already discussed in quite length, and there you could also find utility. I could go on, but I think these should prove the point. The second question by Diego, I would say there that the reason why I referred to conclusion number 3 is, well, if you consider that customary international law is jus dispositivum, and that states in principle could have practice which violates existing rules because they want to create a new rule. They simply want to go a different direction. Inserting that presumption already at that stage, I think is a little bit putting the carts, wait, which way is it? The cart before the horse. Yes, that's the correct way. Because first you would have to look at state practice and elements of opinio juris, and then try and make a decision there about whether a rule exists. And then, based on that, you compare what you found, or your, let's say, not the rule that existed, your nominal, your idea of a customary rule, with the existing framework, and try and figure out whether you're going to go for a principle of harmonization at that particular stage. At least that would be my view. But even if you don't take that, and you would accept that it applies even at that early level, and I do accept that that could be a possibility, then at least then you need that it's not simply about state practice and opinion juris about that particular rule. You kind of insert other elements in the two-element approach. So it becomes more of a melange of elements rather than a straightforward two-element approach. And then still, that doesn't respond to, well, why can't you do it afterwards as well?
Indeed, and you have to go into a lot of assumptions at the same time. How do you consider the legal order? Is it a complete legal order, or do you accept the idea that there are gaps or some vacuum? And depending on the answer you provide to this question, then, of course, if you don't consider that there are any gaps, any practice or any customary rules begins by being a contra legem practice, and then install itself. So, I mean, it really depends on your assumptions as well. But Malgosia, I would like maybe to add a few words.
Well, I have a sort of comment about systemic integration, and actually I am scared of it a bit. Because it's taking into account other rules of international law. But in the court practice, it was actually combined element of systemic integration with evolutionary interpretation. I think you agree with me. In very well known to me whaling case, the interpretation of the Whaling Convention, which is quite aged, from 1946, already certain judges in dissenting opinions based them on the principle of systemic integration, and comparing them with certain treaties like CITES Convention on Trade in Endangered Species of Wild Animals and Plants, Biodiversity Convention, and other newer conventions. And then it actually raised a question in my mind. Is it really a systemic integration? We are comparing a convention which came to life in 1946 and was based on the principles which were current at this time, with comparing with conventions which are based on new ecological principles which developed very recently. So I think it's a combination of systemic integration with evolutionary interpretation, which in my view erodes to some extent consent to be bound and also maybe standing of the states. because Japan was very firmly positioned in interpretation of preamble to Vienna, to Whaling Convention as it was drafted then. And basically, I think that bringing in new conventions based on modern principles, it's somewhat, in a way, inroads the principle of consent. So I think we have to be really careful with this kind of application of systemic integration. What do you think, Panos?
I will just add, because I won't give back the floor immediately. We have one more question there, please. I will just add in the meantime that the appellate body of WTO proceeded exactly the same way in 1998 in the shrimp case, when updating the interpretation of Article 20 of the GATT to consider that natural resources referred there were included biological resources. And it was not the mindset in 1947, because where they consider only mineral resources, because it's a reference to exhaustible resources. And it took 50 years to realize that including renewable resources are exhaustible. So you have a change in interpretation. So you can say, yes, change in consent, but at the same time, in the meantime, states have adopted many instruments thanks to Article 31.3 from C, they can be taken into account. And so you can also consider that they have updated their consent through the adoption of these instruments. So I just opened the discussion there. And I think it's also a nice transition to the next panel, which comes just after lunch, because we will take into account the customary rules for protection of humans and their environment. But before offering you a break, we have a last question.
Hello, I'm Tredafnos Kouloufakos. I'm a researcher at the KU11 University. My question originally was intended for Professor Dehu, but now I want to ask Professor Fitzmaurice as well. This rigidity of only abiding by the primacy of textual interpretation and calling auxiliary methods the object and purpose interpretation, doesn't it deprive international law from the very much needed flexible tools, for example, evolutionary interpretation? Because with only the primacy of textual interpretation, evolutionary interpretation comes second. And on that, I would like to ask that erosion that Professor Fitzmaurice talked about. Is that erosion of consent, or is that the need for flexibility for international law, which is very much condemned for being a very slow and rigid system that change is very difficult? Because why create a new convention, create a new rule, when we can interpret it up to modern standards and not be stuck to a convention that was made in 1946, when now the morals, the ethics, and the law has changed? And finally, if we abide by that primacy and the cardinal textual interpretation, how are we going to even try to interpret customary international law when there's no text?
Just, we would need to know flexibility for whom?
Flexibility for international law itself, for changing.
But international law is a concept. It's
yes,
an idea. I mean, who is in charge of implementing or benefiting from this flexibility? Because this is there you find the stakes of power. So I think you have to clarify flexibility for whom? Judges, states?
I would say flexibility for international law and maybe for judges, applying those concepts to today's society.
First of all, let me challenge your premise. Why should law be flexible? The whole point of having law is that we have agreed rules which ensure a certain certainty and predictability of how we're going to deal with relations between people. This is, of course, the case in national law, but the thing is, in national law, we can change the law relatively easily. Of course, sometimes with unconstitutional means, you know, by decrees which are not actually provided in the constitution and this and that, but it's possible. And that kind of goes to your second point on the temporal element, which is that international law is indeed difficult to change. This is the fact. You see it even on issues of human rights, where we have certain bodies which sometimes too progressively develop the law, because states do not actually change the rules. They could, you know, provide clarity on issues if they were simply to use amendment procedures or this or that, but for the most part they tend not to actually do that. And that is, of course, something you do see coming back in the national discourse, for instance, in parliaments and governments, is that international law is so difficult to change because you need all these you know, states parties to come together to have an amendment procedure or a revision conference or this review conference or this or that. So I agree there is a problem there. The question is who should solve it? And you're kind of seeming to say, well, you know, judges should solve it by progressively or evolutively interpreting it, but that's not really the answer. Now, on the issue of the primacy of the text versus evolutive interpretation, I actually believe that generic terms provide a certain flexibility in the first place. So I've had a debate with Panos on this. The generic term commerce can also cover services. And I don't see that as a change of meaning of the text. I see that as an expansion of the qualification of facts that fall within the meaning of the text. I have a bit of the French attitude towards that. So it goes to the qualification of facts that are covered by the scope of application of the meaning of the word, of the rule, rather than per se being a change of things. To give an additional argument, which I thought of later, when the term commerce was used in the 19th century, of course they were thinking in terms of goods. But of course, when you talk about the freedom of commerce on a river, navigation, of course, is included because you have to transport the goods over the river. And what is the transport? It's a service. It's not the good itself. It's a service related to the goods, you might say. So services were already even covered by freedom of navigation and commerce on the river, even in the 19th century.
And I know that Malgosia would like to add something.
Yes, I thank you for your question. It's a very thought-provoking question. But I would, yeah, why should we get stuck in the old convention if we can develop it? And who is going to do it? Judges. When it comes to the court, it's already a contentious issue, obviously. So it's very difficult to conform with the views of the states because they obviously have totally different approaches to interpretation. But as André already said, they are, I would say, more peaceful means of developing convention to comply with modern times and modern law. Obviously, amendment. It's a good procedure, but it takes ages. Amendment to a convention goes through parliamentary procedure. Sometimes convention is amended when it's already not contemporary or the rule is not really so important. But I would like to turn your attention to a new phenomenon of, at least very much pronounced in environmental law, of the role of conference of the parties and meetings of the parties, which actually take decisions. I know, but I just want to, you know,
You want to spoil the
I want to just signal that, as we will hear later, it's, it's a very good way of bringing a little bit updating convention. Also, let me give you an example again of the Whaling Convention and the Whaling Commission. I hope I'm not spoiling anything. It has various committees, and especially scientific commission, and these commissions are very up to date and they update the convention. So without really involvement of the court, of the amendment, for example, the whaling convention is now more about whale watching and basically protection of whales than whale hunting. So through very humble way of switching the focus of the convention, we can also bring it more up to date.
Thank you very much. Thank you very much to all the panelists for their very rich contribution, and also thank you to the audience for the very rich dialogue which followed the presentations. And so thanks to all.